वो थोड़ा कहीं काम से बाहर है।
कोई बात
From the daily list, fixed case. I am ready for final disposal. Item 1, WPL 4039 of 2005, along with item 2.
Your Lordship, in this case, I am paying for pass, not today, because Mr. Manish Kumar is out of station, Your Lordship. And on last occasion, he has asked to contact the client, but he was not able to contact them, Your Lordship. So it may be decided on merit on next week, Your Lordship.
Leadership, in this case, I am also praying for time. What has happened, leadership, we have received Wakalatnama and file of Wakalatnama on behalf of the petitioner is yesterday or day before, leadership. So I was praying that a date will be fixed. And earlier, leadership.
Yes, some other council was appearing.
Leadership, earlier, Ms. Lakshmi Kumar was appearing. Now, leadership, Wakalatnama has been given to Mr. Eknath's leadership.
So you should have been ready by now. You should have received the records. Have you?
I have got a copy
So?
of the records, leadership, but we could not. Just yesterday, it has been filed.
When the date is fixed in the matter, you
Yes,
suddenly
I was
come and say that.
I was arguing an instruction.
Yes.
Today also I have given instruction to argue the matter.
We do not know they have filed fresh wakalatnama. They have already filed it.
From the legal department, I have
We
today
do not
also
know.
I was called and I have.
They must have given him the wakalatnama, no?
Yes.
Then
No objection has been taken, and today itself I have been instructed to argue the matter.
बिना no objection के फाइल करनी है वकालतनामा.
Leadership, it may be passed over, it will be clarified if I directly ask him to appear and clarify.
No, we do not know why no objection के बिना आप लोग
Leadership,
वकालतनामा फाइल करके यहाँ झगड़ा कर रहे हैं.
That is the situation because
Call
This
Mr. Das.
This
Because-
matter was heard also in part, and some
Yes, it was
instructions.
substantially
other
heard.
side,
Suddenly
yes.
somebody may
Other
ask
side-
like,
leadership,
Other side
that is
said
why
that,
leadership was praying it will be passed over. I will consider the simple.
Other
It will
side
be in a
said
better
that I will
person
seek
like-
instruction if they are ready to take some amount on that
and with the
statement.
consent, this was
Yes.
posted today to be taken up at 2:15.
Yes. And only instruction.
ऐसे हम जो है ना आप लोग का केस एडजर्न नहीं करेंगे बिना कॉस्ट लगाए.
हमारे ग्राउंड पे एडजर्न नहीं हुआ था, ये लोग
हम नहीं
बोले थे
जानते
कि
हैं.
इंस्ट्रक्शन
आपको
से
क्या ही मतलब है. पिटिशनर दिया है उनको वकालतनामा, ये पेमेंट करेंगे कॉस्ट का. आपको क्या ही सोचना है.
Just leadership pass over few cases.
हाँ, we will not adjourn matters like this.
and neither have been informed, and in the morning
कोर्ट में सबके कंसेंट से डेट फिक्स होता है, उसके बाद सडनली somebody will seek time. You seek time, I will give you time. तो एडवांस नोटिस नहीं, कुछ नहीं, कोई एडजर्नमेंट स्लिप नहीं. केस तब पिकअप होगा. रिस्पोंडेंट भी टाइम मांग रहा है, आप भी टाइम मांग रहे, दोनों जने मिलकर कॉस्ट.
आर्गुमेंट के लिए आए हैं आज।
वो तो बोल रहे हैं उनको उन्होंने वकालतनामा फाइल कर दिया.
सुबह में हमको इंस्ट्रक्शन भी मिला है।
Just-
Yes,
now
Mr.
it
Das,
is-
have you taken no objection before filing your wakalatnama?
Manish has left. He is not coming.
I
Manish has
was
left
arguing
back.
this matter. The
No, you
previous
have
day.
your wakalatnama
No,
filed?
no, there is no wakalatnama. It was a Manish.
in
What
one
my
case-
client instructed. If my landed friend has a wakalatnama, I will withdraw it myself.
You have your wakalatnama?
Your Lordship,
नहीं मैडम, आपका भी वकालतनामा नहीं.
मनीष झा का है, हमको जो बोला गया मेरा client
मनीष
से
झा तो भी
हम
नो
अभी
गैस
बता रहे हैं,
Yes.
हम अभी बता रहे हैं। In this matter,
Otherwise, I have
क्या
no-
हुआ हम बता रहे हैं. In this matter I was arguing, और इंस्ट्रक्शन पे ये पिछले बार सुना भी गया था मैटर, सिर्फ इंस्ट्रक्शन के लिए टाइम
मैडम आपसे सीधा सा एक सवाल पूछ रहे हैं, आपका वकालतनामा है इसमें?
हाँ जी, just verify करके बता रहे हैं।
Because client came to me, I said I cannot appear without wakalatnama. Then your lordship, I verified from the records from the
हम
internet.
तुरंत बता रहे हैं।
तो मुझे लगा, मैं देखा कि कोई वकालतनामा फाइल नहीं है. I took it. If the internet में information गलत हो गया, I withdraw my wakalatnama. I'll inform my client.
एक है इसमें 18/5/2018
है,
का.
हाँ, वही तो हम
Net में
बता
नहीं show
रहे
कर रहा
हैं।
था. Then your lordship, let it
All
be
dates I have
adjourned.
appeared, all dates I have
No,
appeared.
I'll talk to my client. Your lordship, there is my client also said that wakalatnama is of Manish.
Morning also I have been instructed to
Then
argue
ठीक
the matter.
है.
नहीं, हम
और एक चीज बता रहे हैं, आपका जो क्लाइंट है वो 22 तारीख को एक एफिडेविट भी फाइल किए हैं
I have filed this.
थ्रू हर.
I do not know. My client said that we are not aware. Lordship, let it come in the next week. हम देख के I'll resolve it. That will not be an issue. I'll withdraw myself. Your Lordship. There is no issue.
तो हम लोग क्या ही करें, आप लोग के कंसेंट से डेट फिक्स होता है, उसके बाद दोनों जने मिलकर डेट मांगते हैं,
नहीं,
क्या चीज के लिए डेट
हम
मांगते
डेट
हैं
नहीं
आप?
हम नहीं
हम
थे
तो आर्ग्यू
इसमें.
करने के लिए रेडी होकर हैं।
If my learned friend argues, I'll with Lordship will observe that there is a wakalatnama. It has been filed with that. I am withdrawing myself. Let my learned friend argue.
रिस्पोंडेंट भी खड़ा होकर टाइम
लास्ट ऑर्डर देख के मैं क्लाइंट को एक चीज बोला. मैं क्लाइंट शायद इनको मेल भी किया था, उसका स्क्रीनशॉट भी हमको व्हाट्सएप किए थे. हम बोले कि आई डोंट वांट एनी कंट्रोवर्सी. बोला उनको वकालतनामा नहीं है, देयरफॉर आई फेल्ड इट, अदरवाइज मैं नहीं लेता. आई एम विड्रॉइंग माय सेल्फ. लेट मी लर्न फ्रॉम
That client has also talked to me और
नहीं,
बोला
ठीक है, withdraw कर देते
बोला
हैं.
कि मैडम उसमें क्या हुआ, और he never said me anything कि no I have.
नहीं मैडम ठीक है. आप इनका सबमिशन रिकॉर्ड करके शी हैज इंस्ट्रक्शंस. आई एम
अरे
विड्रॉइंग.
रिस्पोंडेंट इज सीकिंग टाइम, अब क्या करेंगे हम?
Lordship,
बताइए.
Then let it come in the
station,
next.
Lordship.
So he should not have, you should, उनके कंसेंट से डेट फिक्स हुआ है.
6,000 रुपए का तो खाली डिस्प्यूट है एक केस में.
कंसेंट से डेट फिक्स हुआ ना मैडम?
Yes, sir.
फिर
वो बोले थे कि कुछ पैसा अगर ये ले देकर रेडी होगा तो हम लोग भी दे देंगे कुछ पैसा. 6,000 रुपए का डिस्प्यूट है मैडम मिनिमम वेजेस एक्ट में, और उसमें पार्ट टाइम था, 1.5 साल सिर्फ काम किया, 4 घंटा काम करता था. दैट इज नॉट अ डिस्प्यूटेड फैक्ट. रीस्टेटमेंट
6,000 रुपए के लिए आप लोग
एक
को
केस.
10,000 रुपए का कॉस्ट.
और दूसरा वाला में रीस्टेटमेंट है जो कि ही हैज रिटायर्ड. आई हैव गिवन इंस्ट्रक्शन दैट ही हैज रिटायर्ड.
एक चीज बता दे रहे हैं, बिना एडवांस नोटिस के अगर आज से कोई भी आदमी टाइम मांगेगा ना, तो मिनिमम 5,000 रुपीज बिना कॉस्ट किए हम किसी को टाइम नहीं देंगे ही नहीं हम टाइम. ये 2005 से 2006 से ये मैटर कितना साल हो गया? यस, हाउ मेनी इयर्स?
19 years, Lordship.
सो फॉर 6,000 रुपीज क्या क्या मजाक बना के रखे हैं?
Principal amount is only 6,000 in minimum wages act.
Counsel for the petitioner is present. MS पूरा नाम बताएं अपना, अपना नाम.
Nirupama.
निरुपमा पूरा नाम.
That's it.
Only Nirupama submits that counsel for the respondent Mr. Manish Kumar
Yes, Lordship.
has gone out of station.
Yes, Lordship.
आपको पता था ये बाहर जाने?
हाँ उनको बोले थे. हम ही फोन किए थे. हम कई बार उनको कॉल किए थे कि कल आप लोग, हाँ कल किए थे, तो सुबह में वो फिर हमको कॉल करके बोले कि हम बाहर हैं, मेरे कोई जूनियर टाइम में. तो हम बोले आप अपने जूनियर से बुलवा दीजिएगा. जैसे
The counsel for the petitioner has submitted that she was informed that the counsel for the respondent will not be available today. But no prior notice of adjournment has been circulated. The case was fixed for today with consent of the learned counsel for the parties. Faced with this situation and in order to faced with this situation, the matter is adjourned and is directed to be posted. कब आएंगे?
Lordship, next Wednesday maybe.
Next week
Wednesday,
रहेंगे.
Lordship. Next week रहेंगे.
Next Wednesday
Yes.
at 2:15, subject to payment of cost of ₹5,000. जमा करिए cost.
Cost-
झारखंड लीगल सर्विसेज अथॉरिटी को.
Lordship, बाहर है कुछ
कोई
personal
बात
difficulty
हम
है
नहीं
तो-
जानते हैं. एडवांस नोटिस क्यों नहीं दिया? ये सब नहीं चलेगा यहाँ. प्लीज डोंट डू दिस. 2005 का केस के लिए आप लोग टाइम टू टाइम खाली एडजर्नमेंट देते हैं.
Lordship, उनके रहने पे कॉस्ट कर दिया जाए.
उनके रहने पे तो कॉस्ट नहीं करते, आज एडजर्न नहीं करते. उनके रहने पे सुनते, एडजर्न किसी हालत में नहीं करते.
कॉस्ट को सिर्फ हटा दिया जाए. नेक्स्ट वीक पॉजिटिवली
कॉस्ट क्या है? तो झारखंड लीगल सर्विसेज अथॉरिटी इसमें देना है, हाई कोर्ट लीगल सर्विसेज कमेटी में, हाई कोर्ट लीगल सर्विसेज कमेटी. चलिए नेक्स्ट कॉल.
Item 3 WPL 7063 of 2012.
पिटिशनर की तरफ से क्यों कहते
रेस्पोंडेंट की तरफ से
हैं पिटिशनर की तरफ से अपीयरेंस किसका
अपीयरेंस उनका
रश्मि कुमार।
मिस्टर दास आपका अपीयरेंस नहीं रिकॉर्ड कर रहे हैं. MS रश्मि कुमार का अपीयरेंस रिकॉर्ड करें. आपका
immediately I'll call my client also. It is
फाइंड इट आउट. अबे
embarrassing
आपस में
position, हाँ.
छोटा सा चीज है.
नहीं नहीं हमको embarrassing position मेरे लिए हो गया. I never want to be in a
कोर्ट को भी थोड़ा एम्बैरेसिंग लगता है कि क्या ही हम लोग ये सब बात करें.
जी जी लॉर्डशिप.
अभी तो उनका है वकालतनामा, तो उनका ठीक है? एडमिनिस्ट्रेशन
In this matter, Your Lordship, I tried mentioning in the morning itself, Your Lordship.
क्या हो गया?
My senior Mr. Manoj Tandon has to argue this
अच्छा
case.
अच्छा बताइए कब करें?
On 3rd of December, Your Lordship, if Your Lordship pleases.
Counsel for the petitioner seeks adjournment. Affidavit has been filed.
Yes, Your Lordship. On 25th itself.
He submits that pursuant to order passed by this court, the required affidavit has been filed. Pleadings are complete?
Yes, Your Lordship.
The pleadings are complete. Post this case on next Wednesday.
Yes, Your Lordship.
Okay.
Much obliged.
Final disposal? Final
Yes, Your
disposal में
Lordship.
आइए.
Yes, Your Lordship.
For final disposal.
Obliged.
Item 4 WPL 5392 of 2014.
I'm extremely sorry for the last date I did not appear and also was pleased to appoint an amicus in this case.
नहीं आइएगा तो amicus हम appoint करके disposal कर लेंगे.
नहीं इसको हम आगे
Where
करना
is
चाहते हैं।
MS Monalisha से? वो absent है.
No, she was here.
She was there, she was
She was
reading.
going through the LCRs.
चलिए बहस कर.
जी
amicus appoint करने का मतलब थोड़ी है कि आपका वकालतनामा हम खारिज कर देंगे. Just not like that. We seek assistance. If you do not appear, we will decide that.
yes yes I am agreeing.
बहस करिए.
But sir, against the reference notes, wherein the issue before the reference was whether the action of the management of community area of Messrs. Fire Protocol Limited post community embark in dismissing from service Sri Puram Mathur is justified, if not toward release, the workman is entitled for. This was for the reference and where it was dismissed by the criminal notes, and against that, hearing of this. Charge sheet is just page 12 now. 3 dates are very important in this case now. My point of view, 3 dates now. It's of 11/9/80 and 19/9/80, 22/9/80 and 25/9/80.
11/9,
1980,
11/9/80, 19/9/80,
and 22/9/80
22/9/80.
and 25/9/80. Looks on 25, the inquiry officer was to conduct the inquiry. On the same day, he conducted.
What is the relevance of 11/9?
11/9 is the date on which the occurrence took place. There is a
Date of
allegation that
occurrence.
some mob came before the office.
Date of occurrence.
Yes, date of occurrence.
19/9
99 is the date of charge sheet.
charge sheet.
And 22/9/80 is the date of giving me the notice of inquiry. It was sent through certificate of postage. By post it was sent. And on 25 the inquiry was done.
In your absence.
In absence, ex parte. On 25/9 inquiry was done. On 25/9 report was submitted. On 25/9/80 I was dismissed. Same day inquiry report submitted. Disciplinary authority took the decision and I was dismissed.
What happened to the objection in connection with domestic inquiry being fair and proper? Was it decided as a preliminary issue or not?
It was preliminary issue. Preliminary issue, as per my knowledge, was the petitioner was not available with any of the
So
inquiry.
before the tribunal.
So on 11/9,
Before the tribunal.
before
Was
the
it taken up as a preliminary issue?
no, but it has not been taken by the tribunal as a preliminary
Are you
issue.
aware?
Yes. Internal page number 5, running page number 13. Para 7.
Yes.
Before
What is the
taking
date?
up,
What is the date on which it was held to be fair and proper?
Ladyship, the date exactly has not been mentioned from the LCR, but it has been mentioned before taking up the case on merit, fairness and propriety of the domestic inquiry was taken up as the preliminary issue in which management examined one witness, Ms. R.N. Ganguly, inquiry officer, as MW1, and documents on their behalf have been marked as exhibit M1 to M9 by 1. This tribunal, however, considering evidence, facts, and circumstances, held the domestic inquiry as fair and proper in accordance with the principles of natural justice. Thereafter, the case was fixed for hearing on merits. Parties.
In which he did not appear.
He did not.
Lord's notice was sent to me in my wrong address. Kindly see the order.
Which notice are you talking
Yes,
about?
in notice of inquiry.
No, but the domestic inquiry has been held to be fair and proper.
Lords, that was also not in my presence, Lord. I was not a part of that domestic inquiry. On 11/9/80, the petitioner was working as a minor loader, Lord. He was on duty from 7 a.m. to 3 p.m. My specific case of that is no, Lords. On the date of occurrence, the petitioner was on duty, Lords.
Leadership, may I point a few points?
Just a moment. We have the entire record slip. We
Yes,
just
yes.
have
From
it.
the record itself, I was trying to point out.
Yes.
Yes. Leadership, the LCR from M1 to M9, page 40 to 162 are the exhibits. None of the exhibits have been exhibited by the workman. The management has exhibited. Now, leadership, the most important is WS by the workman. That has to be seen. That starts from page 22 to 25.
But this workman has not given any reply. Written statement.
WS of workman, page number
See,
22 to 25.
whether the domestic inquiry was fair and proper is a very important finding.
Yes, yes, I am going in that only.
So where is that order? What is the date of that order?
That order, लेकिन that ground has nowhere been taken by the workman in any of the, neither in the rejoinder nor in the WS. छः पाँच नौ का होना चाहिए लेडीशिप because on the same date notices were sent. For fixing the date for hearing.
Two 2009.
जी नोटिस वो जो पढ़े थे अभी फेयर एंड प्रॉपर वाला उसके नीचे नोटिसेस डेटेड 6/5/2009 वी आर सेंट टू द पार्टीज फॉर 17/9/2009 17/6/2009
You have conceded that the inquiry was fair and proper. लीजिए पढ़ी इसीलिए रिकॉर्ड मंगा लीजिए.
And this ground has also not been taken any
Just see.
WS and rejoinder to the WS.
In the year 1992, he conceded that the inquiry was fair and proper. So अब क्या ही बच गया? And before the court, you did not appear in spite of notices. And then your main contention was that the criminal case was pending.
Yes.
Yes, that was the main.
So your domestic inquiry being unfair will not be entertained. That ground will not be entertained.
But it's the advocates.
एडवोकेट की गलती के कारण सबको सफर करना पड़ता है. वो जमाना चला गया कि एडवोकेट के कारण कोई सफर ना करे. I don't believe in this theory.
That's merely just saying that 11/9 का इंसिडेंट होता है.
कोई बात नहीं, उससे कोई मतलब नहीं है. अब आप सीधे मेरिट पे आ जाइए. Domestic inquiry was fair and proper, and on your concession it was recorded that it is fair and proper. And you have not even challenged that order. It is not under challenge before this court also. Yes, proceed now on merit. Thereafter you did not appear.
Merit, my merit is only that not within a on the date of occurrence, not the petitioner was on duty, was under mine, and there is no chance of his appearing in such type of mob and violence. And he has repeatedly appeared before the authority for his joining, but he was not given, and he was not informed that any inquiry is being conducted against you. And kindly
So
see the
inquiry was not fair and proper. This is what you
yes,
want.
Lord. Kindly see the deposition of the inquiry officer, Lord, at page 34, running page 34.
to
34. I conducted the inquiry as an officer of BCCL, and at that time I was posted at the headquarters of BCCL. I did not issue any notice as inquiry officer directing the workmen involved to attend the inquiry. The full pages of the newspaper in which the notice of inquiry was published were not produced before me in the inquiry. I cannot say if for the self-same occurrence a criminal case was pending against the concerned workmen. It was not within my knowledge if in the same issue of the newspaper it was reported that the concerned workmen were languishing in prison in connection with the criminal case. True it is that on the first date of inquiry, notice of which was issued by different person, I completed the inquiry by examining all the witnesses. Lord, the inquiry officer has neither sent any notice. He was not aware whether the workman is in prison or not, whether any criminal proceeding is initiated against them or not. Nothing is informed. He simply come out, and in a single day he examined one witness. He examined himself, Arun Ganguly. He is the inquiry officer. He examined himself and passed the order, passed the report. And on the same day, the disciplinary authority also passed the order without giving any opportunity to workman to reply upon the inquiry report. 25/9/80 को ही इन्होंने अपनी रिपोर्ट सबमिट की है हुजूर, और 25/9/80 को ही पेटिशनर जो है वो डिसमिस कर दिया गया है, और इंक्वायरी रिपोर्ट पे हमारा कोई कंसेंट नहीं लिया गया, हमसे हमको कोई रिप्लाई नहीं मांगा गया हुजूर. नो एनी अपॉर्चुनिटी हैज बीन गिवन. Rapidly and hurriedly they have conducted the inquiry and dismissed the workman.
The charge sheet and the notice of inquiry was published in the newspaper.
That was published on 22/9/18.
And what was your written statement? What was your stand in the written statement? Let's have a look at it. What was your written statement? You said some page number, I think.
Yes. Para 6, the pages starts from page 22 to 25.
Of
That is
the
W
LCR?
of the LCR.
Page 22 to 25.
25.
Yes.
Para 6, I'm just pointing
Just,
to, yes.
just show us what
Yes,
is.
para 6 is the workman submitted his reply to the charge sheet. He says that charge sheet was never thereafter in rejoinder. He again denied that charge sheet was not given to him. But here he says that he has given the reply to the charge sheet. In para 7, for the same set of allegation, criminal. This is the only ground that has been taken, that for the same set of allegation, criminal case has been instituted. Para 10, management after completing the empty formality dismissed the concerned workman from the service. So he says that formalities were there, but it was not just for the namesake, the formalities. And para 11 is the dismissal was illegal, arbitrary, just in a casual manner he said, but how it is, the dismissal is illegal, arbitrary, unjustified, nothing has been given in details. Now, Ladyship, WS come rejoinder on behalf of the management, that starts from page 26 to 30. Ladyship, para 7 is important. Charge sheet was sent through registered post, special messenger, and was published in local newspaper Avas, dated 29/1980. Para 9, letter of inquiry dated 22/9/1980 was sent to the concerned workman through registered post on this address. Now the address has been written. This ground has been taken by the workman in the writ application that the address was not correct. However, in the rejoinder, I will show the reply what he has given for this paragraph 9. Thereafter, also special messenger was sent, also published in the local newspaper Avas, dated 23/9/1980. Para 13 is important, my lord. That as per the unanimous decision of the joint bipartite committee, all the central unions condemned the violent act on the part of the workman, including the concerned workman, and no union sponsored the case. He has himself come to the raise the reference dispute. And para 20 is statement in para 6 that the workman replied to the charge sheet is denied. Now rejoinder of the workman starts from page 31 to 36. Here he says he has changed his stand, and he says that no charge sheet was ever issued to the workman. Earlier in his WS he said that he was given a charge sheet and he filed a reply. And para 7 is with respect to paragraph 9 wherein the address is mentioned, ladyship. The statement in para 9 are false. Tribunal is directed is to direct the management to produce the copy of Avas dated 23/9/1990. Not a word has been spelled by the petitioner with respect to the wrong address, that a ground that has been taken in this writ application. No,
As it is, their counsel has conceded.
Yes,
Had he not conceded, then there would have been an occasion to
Yes.
pronounce on that, and then you could have led evidence.
Yes.
But now we cannot do anything about it.
Ladyship, in 1980, this occasion, the occurrence took place. In 1983, again the occurrence took place, and this is the judgment of Honorable Supreme Court, wherein the tribunal and the Honorable single bench and the division bench decided that he should be reinstated into the service, the workman who was involved in writing and assaulted the officials.
Same workman.
No, different workman, but same place,
No,
Munity Colliery.
Person assaulting, there is no question of reinstatement.
हाँ, उसमें वही बोले हैं कि this is insubordination and that too to the extent of assaulting, that should not be brushed aside, and he was.
अच्छा, अब आप थोड़ी देर रुक जाइए, इनसे पूछते हैं। हाँ, बताइए, आपको क्या क्या बोलना है?
तो मेरे को यही कहना है उनको कि इंक्वायरी ऑफिसर हैज नॉट गिवन एनी अपॉर्चुनिटी अपॉन द वर्कमैन to make reply on the report, inquiry reports, and that too it has been hurriedly done. On 25/9/80 inquiry was done. Inquiry was done, and 25/9/80 report was also submitted, and on 25/9/80 workman was
ये
dismissed.
सारा dates हमको कहाँ से मिले?
ये ऑर्डर से ही मिल जाएगा, इम्प्यूट ऑर्डर.
Dates are not displayed.
अच्छा, okay.
These are the dates.
All right.
The inquiry was conducted ex parte on 25/9/80. The inquiry officer drew up the inquiry report on 25/9/80 and submitted the same to the General
That's-
Manager, Chief Manager.
Yes, what else?
One thing more, Nitish. The award was passed in the year 2010 and writ petition was filed in the year 2014. So there is delay in filing the writ petition as well for 4 years.
Yes. अब आप कुछ नहीं बोलिए. Yes, आप बैठिए. Yes, Daddy.
Look, this is my only contention, Lord, that the inquiry has not been held properly. Looks, no any necessary requirement has been fulfilled. The inquiry officer himself admit that he has not sent any report. He has not any inquiry about no report about the workman, that whether he is in prison or not.
Heard the learned counsel appearing on behalf of the parties. This petition has been filed challenging the award dated 26/5/2010, whereby the action of the management respondent in dismissing the petitioner has been held to be justified. The learned counsel for the petitioner has submitted that there has been gross violation of principles of natural justice in this case, inasmuch as the domestic inquiry was conducted in a hurried manner and in a short span of time. The ex parte inquiry was conducted and the petitioner was dismissed from service. The date of occurrence is 11/9/1980 and on 25/9/1980 the inquiry was conducted, the report was prepared and he was dismissed on the same. The learned counsel submits that this aspect of the matter has not been properly considered by the court and therefore the impugned judgment calls for interference. He has also referred to the evidence of the management witness,
Inquiry officer.
who was the inquiry officer, who has stated in cross-examination that he had conducted the inquiry as an officer of BCCL and at that point of time he was posted in the headquarters of BCCL. And the inquiry officer did not issue any notice and he did not issue any notice as inquiry officer directing the workmen involved to attend the inquiry. He submits that even the full page of the newspaper in which the notice of inquiry was published was not produced before the inquiry officer. And the inquiry officer could not say as to whether for the same occurrence any criminal case was pending. The learned counsel appearing on behalf of the respondent on the other hand has vehemently opposed the prayer of the petitioner and has submitted that the domestic inquiry was held to be fair and proper by virtue of the order dated 3/9/1992 passed by the court, and thereafter the matter was taken up in terms of Section 11 Capital A of the Industrial Disputes Act. The domestic inquiry having been held proper, there was no occasion for leading any further evidence in the matter to justify the action of the management, and consequently the management did not adduce any evidence. She has referred to the order dated 3/9/1992 from the records received from the concerned court, and has submitted that it has been recorded therein that at the time of hearing argument on the preliminary issue, the learned advocate for the workman had conceded that the domestic inquiry was held fairly and properly, and accordingly the court held that the domestic inquiry was fair and proper. The court also recorded that the record bears out that domestic inquiry was held fairly and properly, and accordingly it was held that the domestic inquiry was fair and proper, and the next date was fixed in the matter as 29/10/1992 for hearing on the merits of the case. The learned counsel has also submitted that no grievance has been raised by the petitioner in connection with the order dated 3/9/1992, by which the domestic inquiry was held to be fair and proper in the entire petition. Yeah, correct?
Yes.
The learned counsel has further referred to the written statement of the workman and has referred to paragraph 6 to submit that initially the concerned workman had taken a specific stand that he had filed a reply denying the charges, and that the workman represented before the management that for the same charges a criminal case was pending, so the departmental proceedings should not be initiated against him. And a grievance was raised that the management, after completing the empty formality, dismissed the concerned workman in an arbitrary manner. A response, so far as the management was concerned, the written statement of the management revealed that the incident was of the year of 11/9/1980, whereby a mob of workmen armed with deadly weapons like pistol, gun, lathis, iron rod, etc., proceeded towards the office of Munidi project with common intention of abusing, assaulting, injuring, intimidating the officers of the management, and created panic. And the petitioner was a member of the violent mob, and he assaulted the officers of the company. She has further submitted that the charge sheet was sent by registered post and also by certificate of posting, and it was published in the newspaper on 29/1980, and the workman did not file any reply, and the letter of inquiry was also sent to him at his own home address by letter dated 22/9/1980, and finding no response, the inquiry was conducted ex parte.
The notice of inquiry was published in the newspaper.
The notice of inquiry was published in the newspaper. The learned counsel submits that In response to the written statement filed by the management, the workman took a different stand by stating that the charge sheet was never issued to the workman. The newspaper publication was also exhibited before the court as Exhibit 7, N7.
In 7 and 7 by 1 also.
M7 and 7 by 1, and the Pion book was also exhibited as Exhibit M-8. The learned counsel further submits that as recorded in the impugned order itself, the domestic inquiry was held to be fair and proper, and thereafter the notice of hearing was issued to the workman dated 6/5/2009 for appearance on 17/6/2009, but nobody appeared on behalf of the workman, and ultimately the impugned award has been passed by taking care of the stand taken by the petitioner in his written statement, wherein a specific stand was taken that a criminal case was also pending arising out of the same incident.
क्रिमिनल ट्रायल पे जो लेटेस्ट जजमेंट है
वो तो कुछ आया ही नहीं है यहाँ पर
नहीं
that he has been acquitted. What happened?
even if acquitted even
The learned counsel submits that even the final judgment in the criminal case has not been placed on record. She has submitted that otherwise also the criminal case had nothing to do with the domestic inquiry. She submits that after considering the materials, the court held that the court considered that a notice of inquiry was published in the newspaper issued on 23/9/1980, and in spite of such notice, the workman did not appear, and ultimately found that the inquiry was conducted and all the charges leveled against the concerned workman was proved. And considering the nature of allegation, it was held that the dismissal was justified. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that a specific order was drawn by the learned court, by order dated 3/9/1992, holding that the domestic inquiry was fair and proper. And even the counsel appearing on behalf of the petitioner before the learned court conceded with regard to the fact that the domestic inquiry was fair and proper. The said order dated 3/9/1992 is not under challenge in the present proceedings. This court finds that once the domestic inquiry was held to be fair and proper, the court had to consider the case within the scope of Section 11 capital A of the Industrial Disputes Act and the material in the inquiry itself was required to be considered for passing appropriate orders. Consequently, and accordingly, there was no occasion for the court to ask the management to produce evidence for the purposes of satisfying the court with regard to the action taken by the management against the concerned workman. The matter remained pending, and ultimately the impugned and ultimately the impugned award has been passed. The learned counsel has referred to the evidence of the inquiry officer, who has stated that since he was stated in his cross-examination that since at the relevant point of time he was posted at the headquarters of BCCL, he had not issued any notice directing the workman involved to attend the inquiry, and full page of the inquiry newspaper was not produced before him. The learned court ultimately scrutinized the materials on record and has inter alia taken into consideration the publication of the notice of inquiry in the local newspaper, and has also recorded the manner in which the inquiry proceeded. And ultimately held that the charges were proved against the petitioner, and considering the nature of charges, held that the dismissal was proper and did not interfere with the order of dismissal. Although the petitioner has submitted that this court also finds that
Should we submit one
just this court also finds that in the entire petition, the petitioner has before the learned court, before the learned court and also before this court, the petitioner has not raised any grievance in connection with the publication of notice of inquiry in the newspaper, nor it is his case that he had not come across the newspaper report. Although the inquiry appears to have been done in a short time, but considering the totality of facts and circumstances, it cannot be said that inquiry was done without notice to the concerned workman. This court is of the considered view that once the material before the court has been appreciated by the court concerned, and the court has come to the finding there is no scope for interference in under Article 226 of the Constitution of India in absence of any perversity. This court is of the view that the order impugned cannot be said to be perverse. That's all. This court finds no merit in this petition, which is hereby dismissed. You were there, madam? Did you see the record?
Yes, I saw today.
During the lunch. What did you gather out of that? Did you see this order, 1992?
I did not get the opportunity to go through the entire lower court report. That's what I was about to take adjournment today.
Adjournment देने के लिए तो हम amicus appoint ही नहीं करते.
Your Lordship, I did not get the opportunity to go through the LCR. The annexures I went through the record, the rate, the counter, but I couldn't go through the.
This court has also heard the learned amicus along with the counsel.
Item 6, WPC 6511 of 2019.
The last occasion also the counter affidavit has been supplementary affidavit has been filed by the respondent number 7 that I have to file the rejoinder.
Counsel for the parties are present. Counsel for the petitioner seeks grace for time to file rejoinder to the counter affidavit filed by the private respondent.
Yes.
कब तक फाइल करें?
बस एक हफ्ता क्योंकि petitioner is out of station due to death of his brother's son.
Post this case on
12 or 13.
just a moment.
बहुत लंबा नहीं.
Next I will not.
On 13th of January, the reply should be filed latest by 7th of January.
तो सर ये रिजवाइंडर का क्या आने में उसको टाइम थोड़ा लगेगा.
और ज़्यादा टाइम चाहिए?
मैंने 7th के बाद नहीं रिजवाइंडर फाइल करने का मैंने
7th January.
जनवरी.
अगला साल करते हैं?
नहीं
2026.
नहीं हमको तो कम विदिन होते एक वीक
2126.
नहीं just I want 1 week time because the petition is out of station will come within a week.
आपकी बात से ही लग रहा है पिटिशनर को कोई अर्जेंसी नहीं है, तो हमें क्यों अर्जेंसी?
नहीं अर्जेंसी है, एकदम अर्जेंसी है. मेरा पूरा जो सो एक तो काउंटर फाइल कर दिए हैं. You have asked in the last occasion that कि after 28th May 2016 कितने डीड्स हम लगा भी दिए हैं कुछ और रिजवाइंडर में कुछ और हम लगा देंगे. लिस्ट तो पूरा मैंने डीड जो एग्जीक्यूट नंबर ऑफ डीड हैज बीन एग्जीक्यूटेड बाय द कंपनी.
Item 15, WPC 517 of 2020.
Painful not to
Right?
due to some personal difficulty बाहर जाना पड़ा आपको अर्लिंग काउंसिल.
आपको तो सिर्फ नोटिस हुआ है, जाके रिस्पॉन्ड करिए. क्या हुआ? फाइनल ऑर्डर हो गया?
Final order has not been passed, my lord. This is a case of encroachment and re-encroachment, my lord. In 2019, we have issued a notice, and they have removed the encroachment. Again, in 2020, we have issued the notice,
फ्रेश नोटिस.
fresh notice, and that is not under challenge, my lord.
कहाँ है? इसलिए टाइम मांग. नोटिस के अगेंस्ट में आप जाके रिस्पॉन्ड करिए ना.
हम लोगों का कंटेंशन ये है कि जो जमीन है वो गैर मजरूमा खास है, गैर मजरूमा मालिक.
आप अपना कंटेंशन नोटिस के अगेंस्ट में रिस्पॉन्ड करिए, आपको सारा कुछ आपको जवाब वहीं से मिलेगा. यहाँ से क्या मिलेगा?
किसको बस पर्सनल
नहीं, कोई
डिफिकल्टी
पर्सनल
करते हैं.
कुछ नहीं, ये सब एकदम फ्रिवलेस ग्राउंड पे एडजर्नमेंट नहीं होता.
नहीं मैम ऐसा नहीं है.
My lord's annexure A page 39 is the new notice that has been issued, dated 25 to 2020. my lords.
पेज 39.
Page 39 of the counter affidavit filed by state, my lords, on 13/4/24.
Annexure A.
My lord.
आपको फ्रेश नोटिस आया है, दिस नोटिस इज नॉट अंडर चैलेंज, आप इसको रिस्पॉन्ड करें, ठीक है? हो जाएगा आपका काम, देखिए आपको हार्म नहीं कर रहे हैं, ठीक है? कब जाइएगा बताइए रिप्लाई ले।
अगले नेक्स्ट वीक में करूँगा।
हाँ
नेक्स्ट वीक।
नेक्स्ट वीक में आप रिप्लाई लेके जाएंगे वहाँ
नहीं
पर।
मैम, अच्छा ये हम पूछ लेते हैं मैम, जो
किनसे पूछेंगे?
क्लाइंट से पिटिशनर है मैम, उन लोगों से पूछ लेते हैं,
आप
क्योंकि
पूछ
बहुत
लीजिए।
सारे
आप पूछ के
पिटिशनर है
बताइए,
मैम, इसलिए।
कोई बात नहीं, पूछ के बताइए। आप बाहर जाइए, पूछ के बताइए,
ठीक
ठीक है? कौन सा दिन, 1-1.5 महीना का दे देंगे,
ठीक
ठीक है? कोई दिक्कत नहीं, खाली पूछ लीजिए कि फ्रेश नोटिस आया है, इसका रिप्लाई कब तक पाइएगा, ठीक? चलिए, just pass on.
Item 16 WPC 989 of 2020.
Petitioner? Where is the petitioner? What is the matter?
Land acquisition matter under coal bearing.
They have a remedy?
They have a remedy under section 14 of the CBA Act.
You have said so in your counter.
Yes, yes.
Where is it?
It is para 6 of my counter. And there is a dispute with respect to the compensation as well. We have already paid the compensation. He has taken that ground but has not implemented any private respondent to this application.
There is a dispute with regard to quantum of compensation or entitlement?
Entitlement to the quantum, to the compensation.
To some other person you have already paid?
Yes, we have already. That we have stated in para 9, 8 and 9 of our counter. And even in the questions, he has taken that ground. The question is involved in the instant writ application. That disbursement of the compensation to the persons not known to the family.
As per para 10, it is Sobha Suri who was the, Turi was the
Yes.
recorded tenant.
Yes.
He had two sons, late Bhakan Tuli and Baku Tuli. Page para 10 of your counter.
Yes, Sir.
So you have given the compensation to them?
Yes, we have given the compensation, and we have also that they said that there is a cloud of doubt with respect to the genealogical table that has been attached to this writ application.
There is a
That
doubt
is in
regarding
the-
that also.
Yes.
That also will be resolved to
Yes, yes,
everything.
These disputed question of facts. Ma'am.
Nobody appears on behalf of the petitioner, nor any prayer for, nor any advance notice for adjournment or any prayer for adjournment has been made when the case is called.
These are the CBI Act's judgment, ladyship's judgment, and other judgments.
The learned counsel for the respondents is present. Prayer quote kar denge. The learned counsel for the respondents has submitted that there are serious dispute involved in this case in connection with genealogy of the recorded tenant also. She has further submitted that as per the counter affidavit, the petitioner has a remedy in terms of section 14 of coal bearing areas within bracket acquisition and development bracket close act 1957. She submits that the tribunal is functional as of now.
Yes,
The petitioner may avail the remedy. She has also submitted that the amount of compensation has already been disbursed to the two sons of Sohba Turi, the recorded tenant, namely late Bhakan Turi and late Balpu Turi. as mentioned in paragraph 10 of the counter affidavit. The learned counsel submits that if the petitioner ultimately succeeds before the tribunal, the amount has to be retrieved from the persons to whom the compensation has been paid, right? And therefore, these persons are also required to be made party before the tribunal, and they are not party in the present proceedings. Although the petitioner is aware that the compensation has already been paid. In paragraph 14 of the writ petition, it has been stated that the compensation has been paid to the heir of Madhu Turi and Jagmohan Turi, but no compensation or employment was ever provided and paid to either Jagdish Turi or his legal heirs. After hearing the counsel for the respondent and considering the nature of dispute involved in the present case, this court is of the considered view that such disputed questions of fact, as pointed out by the learned counsel appearing on behalf of the respondents and appearing from the materials on record, cannot be resolved under writ jurisdiction. Moreover, there is no private respondent in the present case. As per the counter affidavit, the petitioner has remedy under section 14 of Hold Bearing Areas Acquisition and Development Act 1957, to which no rejoinder has been filed. The learned counsel has also produced copy of order dated 19/7/2023 in WPC numbers 6602 of 2004 to submit that the matter has been that the writ petition was disposed of, enabling the petitioner to approach the concerned tribunal constituted under the provisions of the Adversary Act. Considering the totality of facts and circumstances and the nature of dispute involved, the questions of fact cannot be adjudicated. Disputed questions of facts cannot be adjudicated under writ jurisdiction. Therefore, this court is not inclined to proceed any further in this writ petition. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the concerned tribunal constituted under the provisions of the Aforesaid Act of 1957. All the contentions of the parties are left open. That's it.
With respect to the compensation that is in para 9, the compensation has already been paid against the said land to Ugan Turi and several others. This is the name we have.
Okay, ये नहीं होगा.
नहीं.
लाखों बारीक नहीं होगा.
नहीं. Para 9 का.
Para 9 नहीं.
Ugan Turi and several
The
others.
learned counsel for the petitioner has submitted that the compensation in connection with the land involved in this case has been paid to Ugan Turi and several others, as mentioned in paragraph 9 of the counter. जो para 10 का reference है ना उसको plan. ये ना ऑर्डर्स रख लीजिए, यहाँ रख देते हैं, बार बार आपको फोटोकॉपी कराना. एक खाली डाल दीजिए, इसमें से एक और. इसका ऑर्डर हो जाए ना तो इसको वापस दे दीजिए करेंगे. नेक्स्ट
Item 17 WPC 1722 2020 along with item 18 and 19.
All these three batch of cases, they are interlinked with each other.
So therefore, I would request the court to take up the serial number 18, so that is WPC 1515. This is the lead case.
1 5
15 for 2020.
क्या मैटर है?
Matter is, this is with respect to the settlement which has been made in favor of the petitioners. I have challenged initially from the order it looks this is the next party order the order at annexure 9 page 64 is under challenge.
It's an ex parte order.
Ex parte order.
This Annexure 9 is an ex parte order.
Yes, please. Kindly have a look at the page 64.
From where do I get that it is an ex
My lords, second page. Respondents are absent since long. No any pair be taken by the respondent's lawyer after repeated call. Appeal is pending since last 23 years. Therefore, in the end of justice, appeal heard today. Mullers, to understand the factual matrix of this matter, Mullers, I will take Mullers to...
Just a moment. So therefore, your stand has not been considered.
Yes.
Your part has not been considered.
Not been considered.
It was pending since 23 years.
Yes, Mullers, why? Therefore, Mullers, I would like to take Mullers to annexure...
Where is the order sheet?
Order sheet is order sheet, Mullers, at annexure 7. Annexure 7, Mullers, very relevant.
What is the date of the order?
Mullers, there are several orders, Mullers, which needs to be taken care of, Mullers. Mullers, I will take Mullers to page 54, the order dated 15/12/1997, Mullers. From there it starts. Mullers, there are two cases which are interlinked with the same parties. So therefore, Mullers, these two cases were tagged together, Mullers. Appellant represents similar case involved same parties number 330/1996-97. That is also against that also the appeal is here, Mullers. That is also one of the tagged case, Mullers. So both of the case above case on 13/1/1998. Since then, Mullers, the second order, Mullers, that would be 18/5/1998, Mullers. Appellant represent admitted club respondents with RMA 330 of 1996 for hearing on 14/7/1998.
What is the date of the impugned order?
Impugned order, Mullers,
Is 19/8/19.
it is the date is Mullers 19, Mullers, 24/9/19.
24/9/19.
So, Mullers, the manner in which the case has proceeded, Mullers, you will have a look of the order because this case, Mullers, there are two cases which are involved. One is against the settlement and against second case was against the restoration. So, therefore, the parties were same. Those are clubbed together and they were heard together. Though it was clubbed together, Mullers, but the manner in which the case has proceeded all along, Mullers, which will be apparent from the order sheet. No proceeding has been initiated, Mullers. Then suddenly on 17/2/2003, after the lapse of 4 years after clubbing of this matter, here the order sheet says, Mullers, respondent, appellant absent, respondent present. A petition has been filed on behalf of the appellant regarding the call of LCR put up on 5/5/2003. Thereafter, Mullers, after then from 2003, nothing has been done. Finally, this matter comes up in 2007.
Yes, counsel.
2007, after
No order sheet.
12 years.
Lordship, I am appearing for the private
हाँ,
residence.
so एक बात बताइए, ex parte order है ना?
Ex parte नहीं, हुजूर, हम इसमें entire order sheet का copy लगा देते हैं.
नहीं लगा क्या देते? लगा हुआ है.
नहीं, हम हुजूर इसको देख लेते हैं.
देखना है? आप देखिए ना, आपको ऑर्डर शीट देखने में कितना टाइम
There are 3 cases.
एक
Lordship,
पहला केस पहले देख रहे हैं. आप पहला केस देखिए.
Serial number 18.
ये
WPC
1515 of 20.
This is the first case also. There also it erupted as the first case.
शांति जब हम उनसे पूछ रहे हैं ना, कुछ आपसे समझ के ही पूछ रहे हैं, है ना?
ठीक
जी
देखिए ये जो है ना, पेज नंबर 59 आप देखिए,
पेज 59
ठीक?
Appellant represented, respondent absent, put up on 19/6/2001,
उसके बाद नेक्स्ट
3/12/2001. Appellant absent, respondent
आप हमको एक बात बताइए, जो प्रोसीडिंग शीट होता है पुट अप ऑन 19/6/2001, उसके बाद जो 3/12 को मैटर टेकअप होता है, तो कैसे ही किसको पता चलेगा कि 3/12 को टेकअप हो जाएगा मैटर? उसके बाद आप देखिए 7/2/2003, कॉल फॉर एलसीआर हुआ 5/5/2003 को, पुट अप ऑन 5/5/2003, उसके बाद 2007 और उसके बाद 2019। वकील लोग धरना दे के बैठ जाएंगे। बताइए, ऐसे ऑर्डर शीट चलेगा तो कैसे ही क्या होगा? सही है?
नहीं है तो
गलत है ना? इतना आप सीनियर आदमी, आपसे क्या ही बोलेंगे? बताइए,
ये तो
किसी को बिना सुन के ऑर्डर करना सही नहीं है। रिकॉर्ड सुन के सेम ऑर्डर कर दीजिए इनको सुनकर, बट दिस कांट हैपन, वी विल नॉट परमिट दिस।
in all the three cases.
आई डोंट नो, अभी तो एक ही रिकॉर्ड है, सबका एक ही कहानी है।
नहीं, ये जो पहला
एक
केस
पहले
है,
एक केस डिसाइड कर।
नहीं सर, हम हुजूर को बता देते, 3 केस है, तीनों केस इरप्ट हुआ है सेम से, इसीलिए 2008
नहीं बाकी
ये जो
दो
17
अलग अलग ऑर्डर है ना सबका।
नहीं, जो 17 वाला है ये इसी केस का आधार पर जवाबबंदी कायम कर दिए थे, इसीलिए चैलेंज किए हैं इसे, जो पहला वाला केस है, तो दैट इज लिटिल डिफरेंट।
Therefore, if this order goes, all consequential order
Yes,
has
yes,
to go.
yes.
Rest of the 2 cases are consequential orders.
No, ये जो the matter which was clubbed together, ये है जो सीरियल नंबर 19 का, जो WPC 1014।
101 चलो
जी।
दिखाइए।
और इस केस में हुजूर चूंकि ये कह रहे हैं कि पहला वाला केस रिजेक्ट हो गया, इसीलिए इसको भी रिजेक्ट कर देते हैं।
One zero one.
इसमें भी रेस्पोंडेंट्स आर एब्सेंट सिंस लॉन्ग, ये चल रहा है क्या?
चूंकि बोथ मैटर्स आर क्लब्ड टुगेदर,
इसका इंप्यून्ड ऑर्डर का डेट बताइए कहाँ?
बस इसका 2023 का है,
पेज नंबर
बता दीजिए।
ये 330।
Connection 10 page 76.
In the light of this has been passed.
In the light of this earlier order, this has been passed.
ठीक है ना सर? ये भी खत्म। तीसरा केस बताइए।
तीसरा केस था, जमाबंदी क्रिएट हो गया था
As a consequence.
एज ए कॉन्सिक्वेंस, तो उस जमाबंदी को हम चैलेंज किए थे।
That also has to go.
Go.
As a consequence of this order, जमाबंदी has been created.
Yes.
Ultimately, Lordship, the matter will be remanded.
Yes, yes, of course. यहाँ पे हम क्या ही करेंगे? बताइए। ऐसा प्रोसीडिंग होगा तो क्या कर सकते हैं? स्टेट कहाँ है? कैसे होता है? 2003 का वहाँ लिस्ट तो छपता नहीं है, जैसे हाईकोर्ट का लिस्ट छपता है, ठीक है? 2003 के बाद 2007 and then 2019 party absent, an order passed. चलेगा? तो वो तो that is a consequential order. That also has to go. Remanded back to the divisional authority. Divisional order है? किसका order है?
Divisional.
Commissioner का order है. वहाँ जाएगा, उसके बाद we will only say that is a consequential order. Therefore it has to go. And after passing fresh order, the party will proceed. Right? दिखाई जरा consequential order. जब स्टेट खड़ा होके हाँ बोल देना तो हम थोड़े अलर्ट हो जाते हैं. You just tell me that it is a consequential order.
It is a consequential order. Plus, ये writ application से
280. Annexure 12 is under challenge.
मतलब
Annexure 10. Okay, based on RMA 330.
RMA 330.
देखिए. आप प्राइवेट रेस्पोंडेंट है तीनों में सर?
Lots.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner. These writ petitions have been filed for the following reason. The learned counsel for the petitioner submits that that's right, but demand तो होगा ना? The learned counsel for the petitioner has argued the WPC number 1515 of 2020 as the first case and has submitted that the impugned order dated 24/9/2019 passed in RMA case number 280 of 96-97 is an ex parte order so far as the petitioner who was the respondent in the case is concerned. The learned counsel submits that the RMA case was pending since 1996-97 and while passing the impugned order, it has been recorded that the respondents were absent since long and no parley was being taken by the respondents after repeated call, and the appeal was pending since 23 years, and therefore for the ends of justice the appeal was heard ex parte and the matter was decided. He submits that he has referred to the order sheet of the case of RMA case number 280 of 1997 and has submitted that by the order dated 7/2003, a petition was filed for the appellants therein to call for the lower court records, and the matter was directed to be posted on 5/5/2003. Thereafter, the next order sheet is of the year 2007, and thereafter the order sheet is dated 19/8/2019. The learned counsel submits that the matter was taken after a long time and it was heard ex parte on 19/8/2019 and the previous order is of the year 2007. He submits that when the matter was taken up after a long time, either notice should have been issued or 1 or 2 dates should have been given so that the parties could appear and advance their argument. The manner in which the impugned order has been passed, the petitioner has been deprived of advancing arguments on merits of the case and placed the case of the petitioner before the court of learned commissioners and third party litigation. he has also submitted that in the order dated order of 2007, it has been inserted in pen to keep the matter on 19/8/2019, and such endorsement has been made on 6/8/2019. Correct? Which is in the same ink as that which has been mentioned in order dated 19/8/2019. Correct है ना sir? बाद में बताया है
19/8/2007 लॉर्डशिप।
हाँ 19/8/2007 अच्छा वो 19/8/2007 है उसमें 19/8/2019 लिखा हुआ है उसके बाद ये 19/8/2019 को पुट अप करके ऑर्डर कर दीजिए राइट The learned counsel appearing on behalf of the private respondent as well as the state do not dispute the assertions, arguments made by the petitioner on the basis of the order sheet placed on record. However, they submit that the matter may be remanded back for fresh consideration. Correct? After hearing the learned counsel for the parties, this court finds that the matter remained pending before the commissioner for a long time, and on 7/2/2003, the court records was called for, and it was directed to be posted on 5/5/2003, and thereafter an order dated 13/9/2007 was drawn and ultimately the impugned order dated 19/8/2019 was passed. Mentioning that the petitioner who were the respondents before the court of commissioner remained absent. This court is of the considered view that the impugned order has been passed in violation of principles of natural justice, and consequently the same cannot be sustained in the eyes of law, as this has resulted in prejudice to the petitioner in view of the fact that the stand taken by the petitioner has not been taken into consideration. Consequently, the impugned order dated 24/9/2019 passed in RMA case number 280 of 1996-97 is hereby set aside, and the matter is remitted to the Court of Commissioners Santhal Pargana Division Dumka for passing fresh order in accordance with law, taking into consideration after granting an opportunity of hearing to the parties and taking into consideration the materials on record. The parties are directed to appear before the commissioner on 3rd of January 2024. आप भी appear होंगे? You are for the state? State appear होते हैं कि नहीं?
स्टेट
जीपी होता है
जीपी
And upon their appearance, the parties being heard and appropriate order be passed after granting opportunity of hearing to the parties and considering the materials on record within a period of 3 months from the date of appearance. this order is being passed only for the reason that the petitioner has not been granted an opportunity of hearing by the concerned party. अब next case कौन सा आपका?
ये 19 है WPC 1014/2023.
अब WPC 1014.
Lordship may kindly observe that this court has not gone into
हाँ, this court has not gone into the merits of the claim of
Lordship.
rival parties.
Lordship.
WPC number 1014 of 2023. The learned counsel for the petitioner submits that the order impugned in this case has been passed on the ground that RMA case number 280 of 1996-97 has been decided by the order dated 24/9/2019. The learned counsel submits that since the aforesaid order has been, since the order passed in RMA case number 280 of 96-97 has been set aside by this court, therefore the impugned order be also set aside and the matter be remitted back to the commissioner, to the court of commissioner. Okay? It is not in dispute. Nay, upon going through the impugned order, as contained in Annexure 10, apparently the RMA case number 330 of 96-97, which is impugned in WPC number 1014 of 2023, has been decided on the ground that primarily by taking into consideration that RMA case number 280 of 1996-97 has been decided by the order dated 24/9/2019. Since the order in RMA case number 280 of 96-97 has been set aside on grounds on the ground that the petitioner has not been heard, therefore the impugned order in this case being RMA case number 330 of 96-97 is also set aside and the matter is remitted to the commissioner for fresh consideration after granting an opportunity of hearing to the parties. वो भी same terms में, same date. इसके बाद ये third. WPC number 1722 of 2020.
And Lordship may kindly observe below that this court has not.
Yes, same terms.
Lordship.
Not gone into the merits of the case. कोई छूट न जाए. The learned counsel for the petitioner submits that the impugned order in this case dated 17/6/2016. ये तो नहीं है 17/6/20. Impugned order 12/3/2020. कौन सा है डेट? कहाँ है ऑर्डर? The learned counsel for the petitioner has submitted that the impugned action and order in this case are follow-up
Annexure 12.
orders of order passed in RMA case number 330 of 96-97 and RMA case number 280 of 1996-97, which have been set aside by this court in WPC number 1014 of 2023 and 1515 of 2020. And therefore, the impugned order being consequential order be also set aside. However, it may be kept open to the authorities to pass fresh order after the matter is ultimately decided by the Court of Commissioner in RMA case number 280 of 96-97 and RMA case number 330 of 96-97. ठीक है? It is not in dispute that the impugned action and order in this case is consequential to the aforesaid two orders, being RMA case number 280 of 96-97 and RMA case number 330. Direct number भूल जाते. RMA case number 330 of 96-97. these orders and action being consequential, the order dated 12/3/2020 is also satisfied. एक ही order काफी? However, the authorities will be at liberty to pass fresh orders in accordance with law after disposal of the aforesaid 2 RNFs. वो ऑब्जर्वेशन सब ले लेंगे.
Appearance the
Item 20 WPC 162 of 2021.
Miss Senior Advocate Miss Prasasini.
पटना?
Yes,
क्या मैटर है आपका?
BPLE proceeding का pricing के लिए.
तुम सुने थे?
Yes,
तो क्या हुआ?
NCR was.
टाइटल सूट का क्या स्टेटस है? स्टेटस रिपोर्ट नहीं आया. देखिए WPC number 162 of 2020. As per the office note, the status report of title suit number 203 of 2020 as directed by order dated 3/10/2024 has not yet been received. Office is directed to send an express reminder to fax. The status report and entire order sheet. डिलीट ही है यहाँ पर. डेट ऑफ अपलोडिंग में ओवरराइटिंग कैसे? 3 तारीख को ऑर्डर है, 4 तारीख लिखा हुआ है अपलोडिंग का, फिर उसको 21 किया गया है. समझ नहीं आया. हाँ जब पूछिएगा. ये सब डेट में अपलोडिंग एकदम नहीं होना चाहिए ओवरराइटिंग. राइट, ओवरराइटिंग करने से ज़्यादा अच्छा है काटिए और दोबारा लिखिए और इनिशियल लिखिए, अपना सिग्नेचर करिए साथ. ठीक है. देखिए अब इसको 21 लिखा हुआ है और कम्युनिकेट हुआ है 21 को, तो कहाँ से आ जाएगा? ठीक है. इसको जब विनीत किसी तरह पूछिएगा कि ऐसे कैसे है ओवरराइटिंग. नेक्स्ट डे बताइए कब करना है?
3, 4 or 5 any.
5 तारीख तो पोस्ट ऑन 5 कब जाएंगे?
Item 21 WPC 1341 of 2021.
सर बताइए.
stand case in relation to the surcharge case, in which Milord, without show cause and without accepting the audit report, the Joint Registrar, Cooperative Society, PACO, has passed an order against the petitioner that he is liable to refund surcharge rupees 1 crore and 13 lakhs and all. So if your lordship will kindly see page number 30, Annexure 1, then the proceeding was started before the joint registrar, in which some members were there were 8 total.
तो appealable order है, यहाँ क्या कर रहे हैं?
This is the impugned order, Annexure 1.
It is an appealable order, isn't it?
It is an appealable order, but when I filed appeal before the concerned minister, he said that go before the High Court, nothing will be done.
कहाँ लिखे?
हम लिखे हैं।
कहाँ लिखे? या appellate authority के पास गया तो बोल दिया हाई कोर्ट में चले जाइए और आप हाई कोर्ट में आ गए।
लिखा है मैंने, हाई कोर्ट चले जाओ।
बताइए कहाँ है?
Para 17 देखा। Since the impugned order appealable and could have been heard by Minister in charge, Department of Agriculture and Husbandry and Cooperative, Jharkhand, but in spite of local appeal that revised filed by petition, heard and the concerned minister sent a message to the personal secretary that nothing can be done by him since the joint registrar had already passed the impugned order. As such, it will be proper for the petitioner to move before the
आपको मैसेज मिला है? कौन है रेस्पोंडेंट इसमें? यस रेस्पोंडेंट अपील फाइल करके आपका अपील डिसाइड
अभी भी तैयार है, हम लोग इसमें ऑर्डर ये कर दिया जाए मेरा केस काइंडली 1 मिनट सुनने के बाद
आप सुनने का क्या ही है बताइए,
नहीं,
अपील आप फाइल कर दिए हैं,
1 मिनट
उसकी
फाइल
सुनवाई का हम इंतजाम कर देंगे।
हमने ऑडिट कराया तो डिस्ट्रिक्ट ऑडिट ऑफिसर से, उसके हिसाब से जिसका जितना पैसा था वो टोटल एवरीबॉडी वो हैव बीन पेड एंड देयर इज नॉट अ सिंगल क्लेम। जो मेंबर्स हैं कोऑपरेटिव के, नॉट अ सिंगल पर्सन देयर हु हैज क्लेम एनीथिंग टिल डेट एंड ऑर्डर सेज कि कुछ पैसा हमारा अगेंस्ट में रिकवरी किया था, लेकिन हमने खुद ही कहा कि नहीं व्हाट एवर द अमाउंट हैज कम।
आपने किस प्रोविजन में फाइल किया है?
अपील
हाँ, किस प्रोविजन में?
40
नहीं
में।
जरा कोऑपरेटिव से
40 के कोऑपरेटिव झारखंड कोऑपरेटिव सोसाइटी 40 के क्लॉज 3 में है इसका।
सेक्शन 43
ये क्लॉज 40 के 3।
और रजिस्ट्रार ने किस सेक्शन में ऑर्डर पास किया है?
$35 में है इंक्वायरी बाय रजिस्ट्रार।
Where is the state?
Actually, somebody told that the money has not been deposited in the cooperative society. It is, they say he was a secretary petitioner, so entire money is with him. So when I was asked, then I accepted it that the money it is with me, it was with me, And whatever the collection has been made, we have got the proper receipts, original receipts, and we have paid each and every person along with the interest. And there was no hue and cry, no complaint, nothing like that till date. It was a 2016 and 17 financial year, of which the surcharge case was started. Until date, nothing has happened. When this Honorable Court Ordinate Bench issued notice to 1 to 5 and asked to file reply. In reply also it is mentioned
Where
that
is the order passed by the joint, joint
by
registrar?
Annexer 1, this is the impugned order, page number 30.
This is an inquiry under section 40.
Under section 40,
Under section 40 के ना सर 35 40
सरचार्ज केस 40 इंक्वायरी है, इसमें सरचार्ज केस ही किया है। Section 40, my lord, if anything
Where
found
is the
wrong
state?
with reference
काउंटर
to
फाइल हुआ है इसमें
जो
काउंटर फाइल हुआ है
काउंटर है,
तो क्या बोला है इसके आप जो स्टेटमेंट इतना दिए हैं कि
ये
मिनिस्टर साहब आपको बोल दिए हैं
वही कि अवेलेबल है, 10 जगह तो बोला अवेलेबल है,
कोई
इसके
बात
अलावा
कहाँ लिखे बताइए
और तो पाएगा शुरू से ही
चलिए आपको अपील डिसाइड करा देते हैं
मैंने लिया पहले, उसके बाद फिर लिखा है बहुत सारे 12(8) में भी है।
चलिए आपका अपील हम यहीं से डिसाइड करवाते हैं ठीक है तब
लेकिन
जाइएगा
उसमें ये मेरा सबमिशन नोट करके 2-3
नहीं
पैराग्राफ
नहीं नहीं, ऐसा नहीं आपका सबमिशन नोट कर सकते हैं आपने अपील फाइल किया है मिनिस्टर का ऐसा स्टेटमेंट दे दिए
नहीं, हम फिर ग्राउंड देके हम फाइल
फ्रेश
करेंगे।
ग्राउंड नहीं वही जो अपील फाइल किए हैं और फ्रेश ग्राउंड लेना है तो आप लीजिए
वहाँ तो कुछ रिकॉर्ड कुछ नहीं मिलता, उधर कुछ पूरा फैला हुआ है।
आपका है ना रिकॉर्ड के साथ चले जाइए रिट पिटीशन का रिकॉर्ड है उसके साथ चले जाइए ठीक WPS नंबर 1341 ऑफ 2020 S क्यों है ये C होना चाहिए ना WPC number 1341 of 2021. Counsel for the petitioner is present. Nobody appears on behalf of the respondents. This petition has been filed for the following relief. The learned counsel for the petition, upon a query of this court, the learned counsel for the petitioner has submitted that the petitioner has an alternative remedy and he has filed an appeal also, but he has made a specific statement in paragraph 17 of the writ petition that the appeal filed and that the concerned minister sent a message through his personal secretary that nothing could be done by him since the joint registrar has already passed the order impugned. And therefore, it is proper for the petitioner to move the High Court. The further statement has been made in para 18 that the petitioner again filed appeal on 7/1/2021, but same reply was given. From the perusal of the counter affidavit, filed on behalf of the state,
5 minutes.
paragraph
फाइव में के अल्टरनेटिव
अपील के बारे में लिखा हुआ है, सॉरी
पैरा 5 में लिखा हुआ है।
just a moment. In paragraph 5,
Yes, sir.
it has been objected by the state that the surcharge proceeding was initiated under section 40 of Jharkhand Cooperative Societies Act, which is, and a provision of appeal has been provided under section 40 within bracket 3. And since the petitioner has not exhausted the alternative remedy, the writ petition may not be entertained. is not maintained. From the perusal of the records of this case, it is not in dispute that the appeal is maintainable, and as per the writ petition, the appeal was filed, and in response to the averments made in connection with filing of appeal, it has been mentioned in the counter affidavit that that only representation was sent to the Honorable Minister, and the same cannot be termed as appeal. It has also been asserted that the Honorable Minister's court is running in full swing and all the cases are being regularly taken. Considering the aforesaid averments made in the writ petition and the counter affidavit, this court is of the view that the impugned order being appealable, the writ petition is not maintainable as it involves disputed questions of facts. Further, it appears that certain representation was made by the petitioner before the concerned minister. Representation and
We will redraft. I will be allowed to redraft.
just a moment. And other petitions were filed by the petitioner stating it to be, and the petitioner claims it to be appealed. This court is of the considered view that the petitioner may approach this court under the appropriate circumstances. This court hereby disposes of the writ petition, enabling the petitioner to file a proper appeal within a period of 2 months from today against the order impugned in this writ petition. Along with a copy of the writ records. If such an appeal is filed, the same be heard and be decided as expeditiously as possible, preferably within a period of 3 months from the date of filing the appeal, after granting an opportunity of hearing to the concerned parties. Ex parte order है, impugned order. ऊपर लिखिएगा. The counsel for the petitioner has submitted that the order impugned in the present writ petition dated 18/6/2018 passed by the Joint Registrar Cooperative Society, Sankhya and Patna Division is an ex parte order. This writ petition is according to this petition.
But it is mentioned in the order कि
इसमें भी
appeal किए.
disposed.
Sorry?
All the respondents here in have appeared before the court on different dates
हम
and
नहीं थे.
different steps taken with.
I have written कि I was
चलिए
absent.
ठीक है.
छोड़िए ना, वो लिखे हैं, वो जो बोले आप उनको बोलते हैं अपील नहीं है, अपील में भेज दे रहे हैं, डिसाइड कर लीजिए,
इसमें
आपका
simple-
अपीयरेंस रिकॉर्ड कर दें.
Yes.
Counsel for the state is present. He submits that the petitioner may approach and file fresh petition. which will in form of appeal, which can be decided on the case.
Simple disposal करके
Simple disposal कर
like
एकदम simple.
otherwise हमको
Item 22 WPC 1495 of 2021.
बताइए.
I pray for not to develop. Because Mr. Rajesh Kumar will argue in this case.
Who will argue?
Rajesh Kumar. Now he is engaging for number 3.
क्या matter है बताइए.
Matter is related with Khas Mahal Authority for which renewal.
क्या ही हो सकता है इसमें?
Lordship, this is the second litigation. Earlier they had filed in the form of criminal writ. That was withdrawn, dismissed as withdrawn. They filed an application before the district sub-divisional officer Palam, which was entertained, which after hearing both the parties again that was dismissed. I am the intervener responding number 6 and 7.
आप कौन है?
I am the
आपके
intervener.
साथ लीज हो गया क्या?
मेरे साथ लीज हो गया, मेरे फेवर में है. It has been in my favor. The holding has also been allotted by the corporation.
Independency of this
And-
matter.
क्या? आपका रिन्यूअल का क्या प्रोविजन है रिन्यूअल?
And now, Lordship, one important.
सलामी नहीं दिया होंगे और क्या हुआ?
ये 72 से मेरा पिटीशन पेंडिंग है, उस पर कोई ऑर्डर नहीं हुआ. बीच में रिन्यूअल बंद था, फिर सिर्फ इनिशिएट जब हुआ है सलामी देने के बाद सरकार का लेट में सबमिशन करें तो करें. उसमें उसके बाद फिर जब इनिशियल शुरू हुआ उसमें फिर अपना पिटीशन दिया तो उस पर बिना कोई ऑर्डर पास किए हुए इनके उसके लिए फिर पिटीशन हमने फाइल किया वो ड्यूरिंग उसके बाद ये एप्लीकेशन देके लीज करा ले रहे हैं अपने फेवर में. इनका रिन्यूअल नहीं है, फ्रेश लीज है.
अब तो फ्रेश लीज हो गया तब इनको क्या ही करें? ये तो सलामी दे के करवाए होंगे, खास वाली लीज है ना. हाँ
तो मेरा पिटीशन
Thereafter, they have filed title suit in the court.
आप टाइटल सूट भी फाइल कर दिए.
टाइटल सूट पहले से मेरे फेवर में डिग्री था. टाइटल सूट का
अभी
पार्टिसिपेट
पेंडिंग भी है.
अभी recently they have filed.
अभी रिसेंटली भी कोई सूट फाइल कर दिए हैं.
लेट इट मी टेकन अप टुमारो मैं.
Your Ladyship, this may be for 3 weeks, Your Ladyship. Appearing for respondent note 5.
Lordship, that is the original title suit number 49 of 2023. Last year they have filed. 49 of 2020.
उनको plain for copy.
Affidavits
No,
have been
they have
filed
also
on behalf of petitioner as well as the respondent, Your Lordship.
Who are you?
Respondent number 5, Your
Private respondent.
Yeah, Lordship.
What for? He is also private respondent. You are also private
I am
respondent.
respondent number 5, Hari Krishna Sahai.
How are you interested in this property? How are you concerned? You also have a lease.
No, Lordship, he is not there.
आप कौन है? You are in possession.
I am in possession.
No, he says he is in possession.
I have made a family tree also. What happened, Lordship, Ladyship, that the entire
नहीं,
Shahai
let me just understand. आपका क्या है?
This may be adjourned.
वो adjournment के अलावा क्या है?
Your
नहीं,
Ladyship.
क्या चीज है बताइए ना. कल तक तो नहीं फाइल खुलिएगा, अभी बताइए क्या. Who are you? Who is he?
He is respondent number 5.
आप हो तो हमको पता चल रहा है. उसका आगे क्या?
Might be, I think he might be the 2 shops were allotted.
Co-sharer of what? Which property?
The land involved.
Co-sharer of the respondent or co-sharer of the petitioner?
पिटिशनर.
तो ठीक है ना, वो आपका देख रहा है. आपका काम ही क्या है?
Since 2 affidavits have been filed in the month of September and October itself.
एफिडेविट आपके इंटरेस्ट को देख रहे हैं ना.
Assistance, my lord.
व्हाट असिस्टेंट? खासमा प्रॉपर्टी में आपका राइट.
1 week will suffice, my lord. Within a week we will be filing our counter affidavit.
अब तो नया लीज हो गया, सूट फाइल हो गया. क्या करना?
The suit also.
नया सूट भी फाइल हो गया भाई.
Second
यहाँ हम लोग डिसाइड करेंगे क्या?
That I understand.
इसीलिए कल आप बहस करिए.
And I will show the fraud which they have committed.
हमको यहाँ पे फ्रॉड नहीं डिसाइड करना. सूट फाइल कर दिए.
Suit file कर दिया, that I have already mentioned. Why show?
WPC number 1495 of 2021. Counsel for the parties are present. Counsel for the respondent number.
I have 5, 6 and 7.
Respondent number 6 and 7 has submitted that the lease has been executed by the government in their favor and The petitioner has filed a suit.
Yes,
The petitioner
Lord,
has
it is.
filed a title suit, being title suit number
49 of 2023.
49 of 2023 in connection with the same property.
Same property.
In
and-
which the petitioner, in which the private respondent are the defendants.
We have, yes, we have filed the written statement.
He submits that written statement has already been filed. He has also submitted that any pronouncement by this court will have a direct bearing in the suit. At this, counsel for the respondent number 5 seeks adjournment and submits that the matter be postponed. यहाँ पे आप लोग WPC में हाईकोर्ट को बना दिए हैं सिविल कोर्ट। सबका टाइटल हम लोग यहीं पे डिसाइड करेंगे। ये जितना भी पेंडेंसी है ना WPC का, खास तौर पे लैंड मैटर्स आर एब्सोल्युटली अननेसेसरी।
We are not supporting petition. We are opposing.
Keep opposing. It's okay. वहाँ इंटरवेन करिए सुन। ये भी पार्टी है क्या सुन?
I don't know that. I have Lordship fixed it tomorrow.
कल अब सुन लिया, बचा क्या है? बस इनको एक बार
20
सुन
से
लो।
मैं बोला लंबा डेट.
लंबा डेट नहीं है, बहुत लंबा है, 12 घंटा 15 घंटा।
Item 23
एक पास ओवर है ना मिस्टर मेहता? आज नहीं करना?
10 मिनट में तो
10 मिनट में तो हो ही जाएगा ना?
हो जाएगा। नहीं होगा।
नहीं होगा।
नहीं होगा। कल ऐसे ही रहेगा, कल सुबह आके कर लेंगे।
कल सुबह ही कर लेंगे।
हाँ।
ठीक है? कल कर लेंगे। पोस्टपोन।
सप्लीमेंट्री में रहेगा।
सप्लीमेंट्री में रहेगा, 10:30 बजे कर लेंगे। आप लोग आ जाइए।
Item 23 WPL 2199 of 2021 along with item 24 to 41.
Yes, what is it all about?
All the cases, Lordship, the exemption for certain years have been refused. For some period, it has been granted. Now, Lordship, as a counsel, I may point out at the very outset, some of the cases, Lordship, that has been filed directly before the division bench, wherein the validity of 91A was also checked. There is an interim order and that is likely to come up for hearing.
No, we are not concerned with that. यहाँ पे तो नहीं challenge है ना?
Exemption नहीं, exemption का ही, अगर वो चला जाएगा तो सब कुछ
Exemption पे चला जाएगा तो वैसे ही चला जाएगा, फिर भाई इस ग्राउंड पे हम इस केस को एडजर्न नहीं करेंगे।
ठीक, इसमें केस 2-3 ग्राउंड्स हैं Lordship.
2-3 ग्राउंड आप बहस करिए, जो इसमें ग्राउंड है उतना बहस करिए।
Besides what we say, what they say, Lordship, they found they had granted us exemption for certain. Lordship, kindly come to page 24.
24. इसको तो केस हम भी डिसाइड किए, क्या हुआ उसमें?
decided, I think the Beldy club matter.
I don't remember.
That was a different issue altogether.
Not an exemption.
No, I have decided one case on exemption also.
So one case, Lordship, remanded back if the authority who had decided did not hear it. Therefore, Lordship remanded the matter back in one case. We were only appearing.
अच्छा बताइए।
Now, your Lordship will take
And
into
next page
consideration.
number?
Lordship, page 24.
20?
24. Lordship, the state government granted us exemption for the period 1/1/2015 to Lordship. Every year we have to apply prior to expiry of the year.
Yes.
We applied. They granted us exemption on 1/1/2015 to 31/12/2020. 2015. Now, your Lordship, can you turn to the next page?
But the exemption was granted subsequently.
Yes, they keep it pending. They sleep over. There is no. We have to. The obligation is on us to make an application within time.
And
they have a right to
they
sleep
can
over it.
conduct the inspection anytime.
Yes,
Okay,
they
fine.
can. Actually, it
There
is
is
not a question of
exemption.
inspection. It is a case where, Your Lordship, there is a provision for grant of exemption under the Act, Section 87, which says, Your Lordship, that if you are providing facilities at par, Your Lordship, then we are entitled or substantially at par. Now, Your Lordship, they found that we are giving facilities at par. They grant us exemption. Lordship, first page 24. Second, Your Lordship, for the subsequent period, page 25. Now, Lordship, at their whims, for the subsequent period they reject. Lordship, the issue is, Lordship, if they want to reject it for the subsequent or the prior period, they have to show that which facility which I was providing at the time of grant of exemption has been withdrawn by me. Or what is the change circumstances for which they can refuse exemption. It is a
This is the order of refusal.
Yes.
Did you apply in time?
We have applied in time, those are not in dispute.
Okay. What is the reason
Kindly see
for
the
exemption?
rejection order at page 23. Page 53, I beg apology, Annex 7. Karamchari, Lordship.
Yes.
I am reading out. कर्मचारी राज्य बीमा अधिनियम के अंडर सेक्शन 87/88 सहपाठित 91A के अंतर्गत जनवरी 2014 टू दिसंबर 2014 एंड जनवरी 2017 से मार्च 2017 तक के लिए मिसेस TML ड्राइव लाइन्स लिमिटेड जमशेदपुर को विमुक्ति के आवेदन में निम्नलिखित धाराओं को अस्वीकृत किया जाता है। 1. चिकित्सा हित लाभ। कर्मचारी राज्य बीमा निगम द्वारा चिकित्सा हित लाभ पूरे भारतवर्ष में कहीं भी कभी किसी भी आधार पर कराई जा सकती है। साथ ही कर्मचारी अपने परिवार के आश्रित जनों को सुविधा के अनुसार 2 चिकित्सालय के चयन कर सकते हैं और आवश्यकता अनुसार ESI अस्पताल या लॉटरी में कैली मार्क टाई अप का सुविधा के द्वारा सेकेंडरी एंड सुपरिटी स्पेशलिटी हॉस्पिटल में इलाज के लिए भारतवर्ष में कहीं भी कराया जा सकता है। जबकि कंपनी द्वारा देय चिकित्सा सुविधा टाटा मोटर्स का हॉस्पिटल में प्रदान की जाती है। साथ ही कर्मचारी को चिकित्सा हेतु रेफरल सुविधा कुछ खास स्थानों पे किया जाता है। प्रश्न में कैंडल मार्क ये अपना में लिख देते टाई अप है। दे आल्सो डोंट हैव सुपर स्पेशलिटी हॉस्पिटल। हाँ, ये बोलते मेरा टाई अप है, वहाँ कराया जा सकता है, मेरा बोलता रेफरल हॉस्पिटल है, बट जस्ट बाय चेंजिंग द नेम। सेकंड, बीमारी हित लाभ। कर्मचारी राज्य बीमा निगम के द्वारा इस हित लाभ के अंतर्गत कुल 91 डेज के लिए औसत दैनिक मजदूरी के 70% देय है। साथ ही कर्मचारी बीमा अधिनियम के अंतर्गत कर्मचारी का निबंधन होने पे उनके किसी भी अवकाश पर प्रभाव नहीं पड़ता है। जबकि कंपनी द्वारा इस हित लाभ के अंतर्गत अपने कर्मचारी को वर्ष में उपलब्ध छुट्टियों यथा प्रोविजनल लीव, सिक लीव, कैजुअल लीव आदि ही दिए जाने का प्रावधान है। सभी छुट्टियों को कुल मिला के 47 डेज का देय है। लॉटशिप में kindly come to page 30. I pause here for a moment. Kindly see what we have applied, what we have stated, and what they are writing. They are writing something which is not there. Lordship, may kindly see page 30. These are the facilities we are giving. Annex 1.
They should be concerned with the facility.
Yes.
How
Lordship,
the
may kindly
number
see.
of leave will
No, kindly see how Lordship, arbitrarily they have acted. Kindly see page 30. Serial 1A. Following benefits are given to the employees if any injury is sustained in the course of employment. Full wages to the employee for the period during which he remains unfit, unlimited to his or her date of superannuation, no waiting period. And they say that 47 days का maximum leave दिया जाता है. Has your lordship seen
page number 33, para number?
Page 30, your lordships.
Page 30.
Yes.
Yes.
Lordship, may kindly see serial 1A. Following benefits, yes. Following benefits are given to the employee if any injury is sustained in the course of employment. Full wages to the employee during the period they remain unfit, limited to his or her superannuation. Naturally, if they remain at home.
For the reason.
Next देखा जाए लॉटशिप 3. विस्तृत बीमारी हित लाभ ESI द्वारा.
विस्तृत बीमारी.
It is prolonged ailment.
Okay.
विस्तारित बीमारी हित लाभ ESI के इस दौरान चिकित्सालय और नगद हित लाभ की अधिकतम अवधि 730 डेज की होती है, जिस दौरान चिकित्सा के साथ साथ उनके संगत अंशदान अवधि के औसत मजदूरी का 80% तक दर से भुगतान किया जाता है। जबकि कंपनी का इस हित लाभ में केवल अंतर्गत 60 दिनों का विशेष अवकाश दिया जाता है, जिसे मुख्यालय में अनुमोदन प्रांत विस्तारित करने का प्रावधान है। 60 days is mentioned and they themselves acknowledge that there is a provision and this apart I will also so परंतु कंपनी के द्वारा ये स्पष्ट नहीं किया गया कि कितनों दिन का, that is unlimited. If my employee is actually we only take a lordship approval because lordship it should not be a lame excuse.
ठीक से बात नहीं किए थे क्या इन लोगों से?
वही दिक्कत है ना लॉर्डशिप।
क्या है?
और ये हम लोग को अप्रोच करते हैं कि हम लोग का हॉस्पिटल दे दीजिए इनको।
Yes.
Ladies,
these are the grounds that you have taken. Yes.
No, he was only a party opposing it. State has
you are
to
opposing it. State का?
Oh, state, yes. No, state.
You are for the state. Then
ESI has to defend.
ESI is absent.
No, ESI is not a state has passed the order. State has to defend their
This is
order.
our order.
This is
Actually,
your order.
before let us going to the order, actually it has been filed in 2021, and there is an amendment under section 91A. Actually, they are claiming retrospective effect also. That cannot be done.
No, I do not know what retrospective effect. they are
Actually, the rate has been filed in 2021. They are claiming the exemption.
They say that they have filed the application for exemption on time.
For that
Is it
purpose,
the reason for rejection that they have not filed it on time?
no, it is not.
Then
Certainly it is not.
that is not the ground. They have filed it on time. You consider it and you reject it. Right?
Initially, it was they were allowed to be exempted. Initially, they have annexed their own document, and from the writ, it's not clear that with respect to these periods, they have also applied for exemption.
Then only you have rejected
What
it.
do you mean? Why have you rejected it then? You should have said that there is no application for exemption.
And what I was referring to was my application.
And what is your
for-
counter affidavit?
And the counter affidavit is only a comparative chart, Your Lordship, that this benefit that.
That's in para 8 regulation. Para 8, 9.
आपके ऑफिसर को कुछ हो जाएगा तो टीएमएच में ही जाएंगे इलाज कराने. करेक्ट? जाते हैं कि नहीं जाते हैं? पूछ के पता कर लीजिए. क्या करते हैं आप लोग इससे? हाँ? शांति नहीं पसंद है. This is for the period?
Lordship, 2014 and 2017 means January 2014 to December 2014 and January 2017 to December 2017.
When did you make this application?
Also within time, before
Within
expiry
time.
of the period.
पीरियड एक्सपायर हो जाएगा तो आप क्यों बैठे हुए थे उसको
और उसके बाद का पीरियड का हमको एग्जाम्पशन दे दिए, 14 का नहीं दिए, 15
नहीं
16 दे
चलेगा
दिए,
ये.
फिर 17 का रिजेक्ट कर दिया.
नहीं चलेगा. आपको जब मन होगा ऑर्डर पास करेंगे. This you pass in 2021. अभी तो इंस्पेक्शन भी नहीं कर सकते कि आप कोई फैसिलिटी नहीं था, ऐसा तो आपका है ही नहीं. That is not your ground. Then
Not
Sir,
only that,
on the grounds
have
of-
also been extended. My case is also there. 2004 to 6 application has been rejected in 2021.
ये नहीं चलेगा.
Employees have taken benefit, retired.
ये नहीं चल
And also
सकता.
the practical difficulty is, suppose I have been granted exemption for 1 year, I have to maintain the entire infrastructure. We have the TMH hospital. We cannot rush for 1-2 years. We
It
can
is
defeat
not
the
your
hospital.
case that any of the facilities have been discontinued. It is not your case. It is also not your case that as per the ESI Act, there was certain amendment and they were supposed to give more benefits.
These are not obviously they are not.
They are not the ground.
From rejection order.
Then क्या किए हैं आप लोग? जब मन होगा तब करेंगे काम. बताइए.
But the reasons have been assigned in the.
तो रीजन बताइए ना. रीजन तो एकदम ही absurd है.
Actually, only reason is that we are ESI is
Only
seen
reason is
also
that they did not
providing
meet you
better
properly.
facility than that of.
The only reason is that they did not meet you properly. ये ESI का यही सब कहानी है. झारखंड में रहते हैं हम लोग, झारखंड के बाहर नहीं रहते. What is it? What changes? What is the subsequent development which has prompted you to pass such an order? बताइए. कोई प्रोविजन ऑफ लॉ चेंज हो गया, कोई रिक्वायरमेंट चेंज हो गया, क्या चेंज? There is a provision for recommendation for better treatment. They have all the facilities. It is not your case that they do not have the facility. ये तो serial number 2 is regarding the other prolonged that बीमारी with लाभ and this विस्तारित बीमारी लाभ means basically कितना दिन का छुट्टी मिलेगा और क्या पैसा मिलेगा, यही तो है. ये लोग तो बोलते हैं कि जितना दिन बीमार रहेंगे उतना दिन का फुल पे मिलेगा, है ना इसमें.
Why not the impugned order in every case is different? Why
You
not?
will see each case separately.
In one of the cases that is
नहीं, अभी one of the case नहीं, पहले इस केस को निपटाएंगे.
Actually, we would leadership would restrict to the impin order itself. There is a comparison has been made between the facility of ESIC hospital and MH. So, the leadership may kindly allow me to refer this from para 1 to again. I will be permitted to read it out. Impin order.
4:30 बज गए.
Let him know tomorrow or next week. It's pleasure of your leadership.
कल नहीं रखे नेक्स्ट वीक रखिएगा तो हम लोग जजमेंट्स का भी कंपाइलेशन बना के दे देंगे.
जजमेंट का क्या काम है?
मतलब सेम इशू पे
इसमें क्या ही जजमेंट?
जजमेंट से अंदर इशू ये भी कि अगर एक बार दे दिए तो दे हैव टू से दैट व्हाट बेनिफिट वी हैव विथड्रॉन दैट दे हैव रिजेक्टेड माय.
देयर इज अ जजमेंट.
यस लॉर्डशिप, कलकत्ता हाई कोर्ट का जजमेंट है. हर इशू पे जितना इशू आते हैं उनका हर इशू का जजमेंट.
There are judgments also. I want to remind you, I have also a question, that the provision says substantially similar or better. So what does substantially similar never means the same. There will be some benefits you may be giving, some benefits which I may be.
Benefits includes
Yes.
Basically, medical benefits are the only benefits they boast of, and that's
It will. In fact, there may be some other benefits which I may not give. But you will have to have an overall approach. And also, you will recollect that the workmen are never consulted. There are affidavits that the workmen say, I don't want to go to ESI.
ESI people would also not go to the
ESI is approaching us that you
the
panel us in your hospital.
The argument they make is that why you have to pay, because it is not specifically, it is not quid pro quo for the services we render to a particular person. It is for the society at large, therefore we need to develop a corpus. Very well, that's your object is the same. But the point is not that I must only contribute if I am not giving other benefits. There's a exemption that has to be construed strictly, but still has to be benefited. And what Mr. Das is arguing is the same point. 1 year, same benefits you grant exemption. Another year, another officer comes rejected. There has to be yardstick.
You see, once you adopt a yardstick, ये कोई assessment ये थोड़ी है कि एक assessment दूसरे के ऊपर rest duty काटा नहीं हो. Once there is a facility which has been provided, and you have given an exemption after application of mine, right? And then what is the subsequent development which has prompted you to withdraw that exemption and not grant them that exemption? Is it something that they have violated from whatever they were providing, or is it something that you have improved upon your hospital? The Tata main, this is TMH?
This is PM Tata
जो भी हॉस्पिटल है, ठीक है? इस हॉस्पिटल से आपने कुछ बेहतर सुविधा बना दी है. एक आध कैंसर ट्रीटमेंट का हॉस्पिटल बना दिए हैं क्या ESI वाले? Yes?
In final multi-specialty hospitals.
इसका तो कोई केस ही नहीं है. जबरदस्ती वाला ऐसा रिजेक्शन मत करिए परेशान करने के लिए. ये जो इम्प्यून ऑर्डर है ना, सब में एनेक्शन नंबर बताएंगे तो कौन कौन सा एनेक्शन नंबर है?
अलग-अलग. In this case,
अलग-अलग है.
In this case, annex 7.
And one of the reasons also is that now in terms of 91, what my learned friend was trying to say, the legislation has come in 2010 that you cannot grant an exemption with retrospective effect. If you make a delay in passing an order of 2 years and then you deny me, then I am helpless. Though we have challenged the validity of 91 pending before division exactly on the same ground.
I remember we have heard that.
Yes, Your Lordship.
And that will not apply in our case because we applied within time.
No. Passing of the order, they are saying that I can't pass an order after the year.
But they can't sit over it, no?
They have sat over it for 2 years and then say 91A prohibits me.
And already there was exemption.
Yes, that's the. And the super specialty argument hospital which is coming up near Namkom, that is the argument they make. Because how inconvenient
coming up, अभी नहीं आया ना?
नहीं हम वो कह रहे आगे बहुत अच्छा हॉस्पिटल है. पर जमशेदपुर का आदमी को फिर आप बोलेंगे रांची आइए हर बार इलाज कराने. हम आपको वहाँ से हटा देते थोड़ा भी बुखार होगा तो
compromise. That is in the future tense. When they establish it, they can say that thereafter will not give exemption for this.
देखिए ये मैटर ये सब पेंडिंग में रहेगा. आप लोग थोड़ा जजमेंट आपस में भी एक्सचेंज करें.
जी.
Some kind of estoppel, if it is possible, once the exemption is already granted, if the circumstances do not change. Apparently लगता है the circumstances do not change. अभी होगा क्या? वकील साहब को एक लाइसेंस दे दिए. अब बोलेगा आप इनकॉम्पिटेंट हो गए.
1 साल प्रैक्टिस कीजिए, 2 साल फिर प्रैक्टिस मत कीजिए.
वकील साहब को वकील साहब की बातें समझ में आती हैं. ऐसे नहीं होता. कब करेंगे बताइए? हाँ?
Because next week I have requested after that.
12.
Yes, that's
कौन कौन है इसमें? आप लोग सुन लिए ना क्या क्या सोच रहे हैं हम लोग?
जी
उस सोच का जवाब
12
दीजिए।
को नहीं रखा जाएगा, फैमिली में थोड़ा शादी
कब?
दूसरे कुछ रखा जाएगा, कल भी रखा जाएगा।
18, 17, 18।
नेक्स्ट वीक नहीं है ना? आप 10 तारीख को है?
10 को?
10 को? 10? 2:15?
10 पे routine has that
क्या ही करेंगे आप? हाँ आपको कुछ करना है। 18 को 18 क्या चल रहा है इलेक्ट्रिसिटी में?
They had met the government of India
Yesterday.
because whenever they got
10 तारीख की तैयारी में।
and we have been having conferences with seniors.
18th को।
We'll give synopsis of each case.
हाँ, तो
Yes.
Short.
So
synopsis एक
what I
file
was
कर दीजिए।
proposing here, subject to, I was preparing a chart which will give an overall picture of
All the cases. Very good.
I will
नहीं
prepare.
आप एक काम करेंगे, एक तो बेसिक डेट्स दे देंगे that you had applied on time.
Yes.
This is very important.
Yes.
किसमें कौन सा पीरियड इन्वॉल्व है और सबका इम्प्यून्ड ऑर्डर का कॉपी
Copy. जी.
एक साथ दे देंगे।
अच्छा।
टाइम के लिए
The matters, the hearing in this matter has been commenced as the court time is over. Hold this case for further hearing on 18th to be taken up at 15th. एडवांस में देंगे भाई, थोड़ा चार्ट वार्ट बना।
जी जी।
आइटम 15
क्या हुआ?
उसका टाइम आपने कहा था कि रिस्पॉन्ड करने के लिए 4 ही टाइम
देखिए WPC number 517 of 2020. The learned counsel for the parties are present. The learned counsel for the this petition has been filed for the following relief. The learned counsel for the respondents has submitted that after during the pendency of this case, the petitioner had removed the encroachment and subsequently fresh encroachment has been done, and consequently fresh notice contained in encroachment case number 1 of 2020-21 has been issued to the petitioner as contained in annexure A to the counter affidavit. He submits that the fresh notice is not under challenge in the present proceedings. सिर्फ एक ही है और भी है? सीताराम?
7 petitions.
7 petitions.
सबका लगाए हैं?
We have annexed also.
Annexure. Fresh notices have been issued as contained in annexure annexed with the counter affidavit. The learned counsel has also submitted that that only notice has been issued. The petitioner may respond to the fresh notices. And so far as the present notices are concerned, they do not survive anymore.
They have removed the encroachment.
They do not survive anymore.
Yes.
And the petitioners have to respond to the fresh notices, correct?
4 weeks.
Yes. The council submits that the fresh notices are not under challenge in the present proceedings. At this, the learned counsel for the petitioner has submitted that the petitioners would respond to the fresh notices as contained in the counter affidavit within a period of 4 weeks from today. In view of the aforesaid submissions made by the counsel for the parties and the fact which has been brought through the counter affidavit that fresh notices have been issued, this petition is disposed of, enabling the petitioner to respond to the fresh notices annexed to the counter affidavit within a period of 1 month from today. Upon their filing of reply to the notices, the circle officer Pandu Palamu, who has issued the notices, shall proceed in accordance with law and dispose of the matter expeditiously. parties to cooperate?
Appearance.